Let's take a look at a key case within the law of tort. This is a case of Transco PLC versus Stockport Metropolitan Borough Council from 2003, and this is a case concerning the tort of Rylands and Fletcher. Let's take a look at the facts of this case. The claimants were Transco PLC and the defendants were Stockport Borough Council. Stockport Borough Council owned a block of flats and an adjacent embankment. Through this embankment ran a gas pipe which was owned by Transco PLC. There was also a pipe that provided water to the flats, and this pipe, through no fault of any party, suffered a fracture and then began to leak. There was a substantial leak which went unnoticed for a considerable amount of time. The water travelled to the embankment and caused it to collapse. This damaged the pipe and also left it exposed, which was significantly dangerous. Transco PLC sought a claim against Stockport Borough Council as the owner of the pipe for the costs to make their own pipe safe, and this was around £93,000. The outcome of this case was that the defendants were not liable, and key to this was that one of the elements of Rylands v Fletcher was not satisfied. The first element of Rylands v Fletcher requires that the defendant has brought something onto their land that is not naturally found there, and secondly, that this must amount to a non-natural use of land. And in this case, it was held that getting a water supply to a block of residential flats was not a non-natural use of that land. The use of land must be shown to be extraordinary and unusual, and this will be determined by the nature of the land in question, and timing will also be considered relevant. But in this case, the piping of water from the supply from the main system to the block of flats was not in any way extraordinary or unusual. So yes, whilst the council were bringing water onto the property, into the flats, which was not normally found there, it had not naturally accumulated there, this did not establish a non-natural use of land. So this case is a key case that you can refer to in an application question when you are trying to establish what is a non-natural use of land. And in this case, they gave us that nice quote, it must be extraordinary and unusual, establishing quite a high and significant threshold in order to meet, in order for something to be a non-natural use of land.